Thank you very much. Lovely connecting again. It's been a good break for us, and in the break we did get into some more work, and we are now in the process of coming up with two good programs. And I think this is something that I should inform before we get on to this. There is one program that is coming up in the workshop mode, and it's the workshop on the NABH fifth edition of hospital standards that we have already announced. There is another good program which will be of 4 weeks duration. It will be a master course that's coming up, is how to create a patient safety culture in the hospital. This is something which is not very well understood, and we also need to see the entire sphere of the patient safety, and therefore that program is in the works. Hopefully within next 2 to 3 weeks time we should be able to finalize, and the plan is to start it sometime. I think 1st of March should be the date. We have Air Marshal Pawan Kapoor and Dr. Sanjeev Singh from Amrita as the faculty of that program. It's a patient safety master course that we will be starting. The workshop on the NABH 5th edition standards is already announced, and you can have a look at this on our learners portal. So with that little bit of beginning, let me get on with the presentation of today. And today's topic is the consent. So consent is a process where a patient agrees for a healthcare intervention. I hope and I think there should be no doubt about it. The first step is that the patient agrees. It's a process where the patient agrees. He agrees voluntarily. He agrees on the basis of information about the risks and benefit of that intervention. This information is provided by the physician or the person or the doctor who is performing this procedure or is going to perform this procedure, and it is on the basis of available medical knowledge. A consent needs to be real and valid, and I'll cover this in a while, what is real consent and what is a valid consent. So moving on. A real consent is something that is actually obtained and it is not implied. So we know that there is something known as implied consent, and we also know that there is something known as a consent which is informed consent. These two flavors we've been hearing this ever since we started our medical careers, and therefore this should be familiar to all of us. So why the term called a real consent? It is because the Supreme Court of India has used this term in a famous case called Miss Samira Kohli versus Dr. Prabha Manchanda. Many of you would have heard about this case, and we will cover a few important aspects that the Supreme Court pointed out in this case. So a real consent is something that is obtained and it is recorded. A valid consent is by a person who is an adult and is in sound mind, or it is by a guardian in sound mind for a minor or for a person who is not in sound mind. So these are the two criteria for a valid consent, and the consent needs to be witnessed. And that is why in most consent forms you will see that there is a place for signature of the witness. Primarily because a witness kind of eliminates the possibility of consent being obtained by means which are not bona fide or which may not be, which somebody can contest subsequently. So witness is an important element of the consent. So having said that, what is the rationale for consent? So the first statement that is here on the slide is the rationale. So the inviolable nature of the patient's right in regard to his body and his right to decide whether he should undergo a particular treatment or a surgery or not. So this right of a person on his body is absolute, and it is a part of what is known as autonomy. So a person is required to decide for himself, and this power or this authority or this right cannot be taken away. The scope of a physician's communications to the patient then must be measured by the patient's need, and that need is the information which is material to the decision making by the patient. Thus, the test of determining whether a particular peril, a risk, must be divulged is its materiality to the patient's decision, and all risks potentially affecting the decision must be unmasked. So these are some of the aspects which have been defined and which have been described in multiple cases which have been decided by the courts, notably by the Supreme Court of India, and therefore these are here on this slide. So let us look at the rationale, and this is what something that was used as a rationale for arriving at the decision by the Supreme Court in the case called Samira Kohli versus Dr. Prabha Manchanda. This is one case which has highlighted a consent and the scope of it. So let us look at it, and first the rationale. So a doctor has to seek and secure the consent of the patient before commencing a treatment, and here a treatment means any procedure which requires a consent or a procedure which is of an invasive nature or a surgery. So a consent is so obtained should be real and valid, which means that the patient should have the capacity and the competence to consent. The consent should be voluntary, and his consent should be on the basis of adequate information concerning the nature of the treatment procedure, so that he knows what he is consenting to. So this is what is the rationale that has been used by the Supreme Court for arriving at the decision in this particular case. There is more. The adequate information is required to be furnished by the doctor or by a member of his team. So this term by a member of his team is also used in the Supreme Court judgment. So this is as sacrosanct as the judgment of the Supreme Court. So the adequate information is to be furnished by the doctor or a member of his team who treats the patient, should enable the patient to make a balanced judgment so as to whether he should submit himself to a particular treatment or not. This means that the doctor should disclose the nature and the procedure of the treatment and its purpose, benefits, and effects, the alternatives, if any, that may be available, an outline of the substantial risk and adverse consequences of refusing the treatment. Next, and this particular slide is also part of the judgment. So it goes on to say, but there is no need to explain remote or theoretical risks involved, which may frighten or confuse a patient and result in refusal of consent for the necessary treatment. Similarly, there is no need to explain the remote or theoretical risks of refusal to take treatment, which may persuade a patient to undergo a fanciful or unnecessary treatment. A balance should be achieved between the need for disclosing necessary and adequate information and at the same time avoid the possibility of the patient being deterred from agreeing to a necessary treatment or offering to undergo an unnecessary treatment. So these are the bounds that the Supreme Court has stated in their judgment. And it goes on to say that consent given only for a diagnostic procedure cannot be considered as a consent for therapeutic treatment. A consent given for a specific treatment will not be valid for conducting some other procedure. The fact that an unauthorized additional surgery is beneficial to the patient, or that it would have saved considerable time, expense of the patient, or would relieve the patient from pain and suffering in future, are not the grounds of defense in an action in tort for negligence or assault or battery. In other words, if the patient contests that the scope of the treatment carried out was more than the scope of the consent given, then these grounds do not constitute defense that the additional surgery was otherwise beneficial, or it would have saved the patient another anesthesia, another risk of surgery, another risk of anesthesia, or the fact that it would have relieved the patient from pain. There is only one exception that the court has said in its decision. The only exception to this rule is where the additional procedure, though unauthorized, is necessary in order to save the life or preserve the health of the patient, and it should be and it would be unreasonable to delay. So the court has not only defined the bounds of the consent, they have also given conditions. They have also qualified it further, saying what constitutes an appropriate consent, and also that additional procedures, unless they have been explained, cannot be included in the treatment. So these are the very, very important bounds, and we need to understand within these bounds as to how to implement the consent process in our hospitals. There can be a common consent for diagnostic and operative procedures where they are contemplated. There can also be a common consent for a particular surgical procedure and an additional procedure or further procedures that may become necessary during the course of surgery. The nature and extent of information to be furnished by the doctor to the patient to secure the consent need not be of stringent and high degree, but should be of the extent which is expected as normal and proper by a body of medical men skilled and experienced in that particular field. So this again boils down to the reasonableness of the explanation that is required to be given to the patient, and also the how much detail should be provided. It will depend on the physical and mental condition of the patient, the nature of the treatment, and the risks and consequences attached to the treatment. So this is how the Supreme Court arrived at a judgment in this particular case, and this being a case law, that means a law which is defined by the judgment of a Supreme Court. This helps us in figuring out in what manner to implement our consent processes in the hospital. So informed consent is one of the main ways where the patients are involved in their care decisions in the hospitals or in our healthcare system. So there are multiple other ways by making the patients aware, but informed consent is one of the main ways where the patient are participating in the care decisions regarding their own treatments. So patient must be informed. We have covered this, and this may be informed consent may be obtained at several points in the care process. We will see what those points are. The hospital is required to develop and implement a clearly defined and informed consent, clearly defined informed consent process, and it should train the staff in that process. Most of us are aware that in the accreditation system as well, notably in the PRE or in the PCC chapter of JCI or PRE chapter of the NABH standards, these are the requirements that have already been spelled out. Patients learn about the process for granting the informed consent in a manner and language that patients understand. The identity of the individual providing the information to the patient and the family is documented in the patient's medical record. So this is something that needs to be recorded, and this is usually done by most of us. It is by recording the name of the person who is obtaining the consent. That means the person who is providing the explanation and the person who is getting the patient's signature. It has to be a doctor performing the procedure or a member of his team. So coming on to the informed consent. So these are the situations where the consent is necessary for any surgery, for every anesthesia, for procedural sedation, for use of blood or blood products, for high-risk treatments and procedures. In case of an unplanned additional procedure for which explicit consent had not been taken before the surgery, a fresh consent needs to be taken. As we have seen earlier, exception is only in situations where a delay will be unreasonable. That means a delay cannot be allowed to happen just to meet the requirement of a consent, or there is an emergent situation. In those situations, the consent is not necessary. Additional consent is not necessary. Similarly, the hospital lists these additional procedures and treatments that require separate consent. This is part of the accreditation compliance requirements, that the list of procedures which require consent is required to be not only recorded but also to be used for training of the hospital staff. Now, who is eligible to give consent? So, consent shall be taken from the patients in all cases where the patient is capable of giving consent above the legal age for giving consent, which in our country is 18 years. No one can consent on behalf of a competent adult. This is something that that I have seen in a large number of observations, and I'm sure most of you are also aware. Especially for elderly, you have the family members volunteering to sign consents, the sons or the daughters signing for their senior, the elderly parents, even though they may be in a perfect condition mental condition to give consent. So this is something that is not acceptable. And the consent, if a person is in sound mind and is able to make a judgment and a decision, then it has to be done by that particular person only, and nobody else can do it on his behalf. When the patient is a child and cannot make decision, a surrogate decision maker is identified, and we'll see how it works. So when someone other than the patient gives the consent, that individual is noted in the patient's record. So when we are using a surrogate, then we need to record who is this surrogate, the name and the relationship. So the hospital is required to develop and implement a process for informed consent within the context of existing law and the culture. There may be statutory requirements for multiple compliance requirements. For example, MPP Act requires a consent. PCPNDT Act, the Transplantation of Human Organ Act, a policy on HIV testing, which has been laid down by the NACO. So all these statutory statutes also require us to obtain consent, and they have attached the confidentiality. For example, in the MTP Act, there may be additional requirements. For example, in the Transplantation of Human Organ Act, in a lot of states, the requirement is to have a video recorded consent. While in the other situations, a video recorded consent may not be necessary, but in the organ transplant, a lot of states insist that there should be a video recorded consent. So we need to be aware that these are the further requirements on consent. The organizations or the hospitals shall have written guidance explaining the various steps required or involved in the informed consent process and the persons responsible. So this will be part of the hospital SOP where the consent procedures are defined. What all it includes? So it includes the information regarding the procedure, risks, benefits, and alternatives, name of the doctor performing the procedure, and in case the procedure requires more than one doctor from different specialties, the same will be explained, and the consent includes the name of all the doctors. This is something that is required in lots of situations where you have a multidisciplinary team of surgeons. You may have let's say, example of a thoracic surgery where you may have a cardiac surgeon also involved. You may have a surgeon who's operating, a vascular surgeon, a thoracic surgeon. You may have multiple team members. And when such is the situation, then the names of all the doctors is required to be included. Similarly, in spine surgeries, a lot of time the orthopedic surgeon and the neurosurgeon both are involved, so that has to be recorded. Salient steps of the procedure and the key intraoperative findings or key findings or what is it that the surgeon is looking to do and what is it the surgeon is looking to operate, that is required to be explained. The likelihood of success and the possible problems related to recovery. For example, in many of the surgeries, there may be a possibility that a ventilator support may be necessary subsequently. In many of the surgeries, there may be a pain. In fact, pain would be something that needs to be explained in details because every surgery will involve some amount of pain. A lot of surgeries, it may have a lot of treatments. There may be a prolonged rehabilitation that may be required. So all that needs to be included. The legal compliance requirements are that the consent has to be taken before the procedure. So it should be part of the checklists in the pre-op room in the operation theatres and in the procedure rooms, where pre-procedure checklist includes whether a consent has been properly recorded, obtained and recorded. At least one witness signing the consent form. The witness shall be a person who was present for the entire duration of the communication between the doctor and the patient. In case of long-term procedures, for example, patients requiring repeated blood transfusion or CKD patients who are on dialysis and need to undergo dialysis once or twice or thrice a week, informed consent can be taken in the first instance and it can have the validity of up to 6 months. And whenever there is a change in the modality, then a fresh consent has to be obtained. And when the procedure is repeated, for each repeat, the consent has to be endorsed. So what it means is that you have a consent form in which in the first instance, the doctor and the patient have signed together and there is a witness. And in the same form, below that, there is a space for the patient to sign every time he comes for that repeat procedure. So if a person is coming for dialysis twice a week, then twice a week he should be signing on that consent form. So it is essentially that the same consent is being endorsed again and again, and this can continue for a period of 6 months. That is what is the requirement. Now, what happens when the patient is incapacitated or a minor? So in such a situation, when the patient is not capable of independent decision making, the organization shall take the statutory norms into consideration. The patient does not have mental or physical capacity to make care decisions, or when cultural customs require that others make care decisions. For example, this culture customs is an issue where you are, let us say, a procedure of vasectomy or tubectomy is being undertaken. The spouse consent becomes necessary. IVF procedures, the spouse consent becomes necessary. And of course, when the patient is not is incapacitated in any way. This could include the next of kin or the legal guardian. And in the order of preference, the order is that you have the spouse, and then you have the children in the order of birth, or if none of them are available, then the parents, followed by brothers and sisters. The son-in-law and the daughter-in-laws and the other people, other significant people for the patient do not come in the context of consent. So we, a lot of times, I have seen this being done in the hospitals. Well, there may be situations where it becomes necessary, but the hospitals need to take care of this requirement, because in the court of law, this doesn't stand unless the appropriate person has signed. So it is not easy to defend when you are in front of in the court, and when you are trying to justify something that was done 3 months, 6 months, or a year earlier. So therefore, it is necessary that we stick to the procedures. Incapacitated patient, for life-threatening situations where the patient may be incapable and the next of kin is not available. In that situation, the consent can be granted by the, or rather taken by the doctor from the administrative authorities in the hospital, and they become the guardian for that purpose. So the treating doctor and another clinician, two people put together, or someone from the administration of the hospital can put together, can decide to safeguard the patient and undertake the procedure. The person performing the procedure shall be responsible for the entire consent process, including the explanation and taking the signatures. A doctor member of the team can take the consent on behalf of the person performing the procedure. We have covered this, just to repeat. And what are the safeguards? Now, in these safeguards are essentially directed as towards aiding the case of the hospital in the court of law, or when there is a medical negligence case made out against the hospital or the patient claims. So therefore, record keeping, we all know, is so necessary, and the record keeping is an aspect that can be discussed subsequently in more details. But needless to say that at this stage, the consent must be recorded, and that paper should be preserved as part of the patient record. Documentation, so all the aspects as we have covered, including the doctor's signature, the patient's signature, or the guardian's signature, and a witness. The appropriateness is the whole concept on which the consent gets decided in the court of law. So therefore, whether the appropriate explanation was made, whether the person who was undertaking the procedure actually explained to the patient, these are the questions that the patients will raise when they are not happy or when they want to make a claim. So therefore, if these are addressed at the time of taking consent, they actually facilitate getting out of the legal complications. So this is all I have to say here. I'll welcome the questions and also the comments. So there are a few questions. If there are any comments, anyone wants to make a comment, please say so before I take on the questions. Okay, so Dr. Rupashri has asked, kindly tell us about the ultrasound guided anesthesia blocks. What consent has to be taken? Madam, the consent, generic aspects of consent do not change with the procedure. However, when you are undertaking this procedure under USG guided anesthesia blocks, there are risks to the patient and they need to be explained. I mean, I don't know what you are looking at, what is it that you expect as an answer. So if you can be a little more explicit about that. Every invasive procedure, even ultrasound guided anesthesia block, may have risks involved. The damage to the nerves or whichever is, I mean, I'm not the specialist of this line, but one can safely comment that there may be risks to the nerves and injuries, and therefore that becomes the aspect of consent process. Is there anything else that you need to know? Please state so. Revati ma'am, you said clarify about the restraint consent. What's the frequency of taking consent? What about the chemical and physical restraints? Okay. So ma'am, the consent is required for restraints, and typically when a restraint is being applied, the patient is not likely to be in a mental condition to agree or to consent for this. So a restraint consent is always from the next of kin. And this is typically valid only for 12 hours because the decision to continue restraint is to be taken, reviewed again. Even if you look at the NABH standards on the restraint, the requirement is that it will be reviewed minimum 12 hourly and more frequently if necessary. So the consent in this situation has to be repeated after every 12 hours. That is what the normal understanding is. You can't have a person under restraints for extended period of time without having to review it frequently enough and without obtaining the appropriate consent frequently enough. I hope that answers your question. The presentation, yes, the presentation will be shared, so that's not an issue. A lot of people have asked. It will be shared, not an issue at all. Absolutely. Okay. Any more comments? Okay, Neha Darbhe has asked, can a patient withdraw even if consent is sought? Yes. So a typical situation is that the patient was seen in the OPD. The surgeon had seen, the treatment was explained, and the patient agreed, and the surgery was scheduled, and a date of admission was given maybe a week later. And then in between, the patient changes his mind and says that, no, I don't want to get operated. Well, yes, the patient has the power to withdraw. He can withdraw and therefore can say that I do not want this treatment now. There may be a need to counsel the patient, especially if the procedure is necessary in the clinical for the clinical requirement. However, the patient gets to decide whether he will undergo that procedure or not. So he can always withdraw the consent. Renu has asked, do we need to have separate surgery-specific consent in terms of risks, or blanket consents with specified common risks would suffice? So, madam, the consent has to be taken for each surgical procedure unless these are combined together in one surgery. And in such a situation, you will explain all these specific procedures, and it will be explained to the patient, recorded in the consent form, that these three procedures are part of one common, in one setting they are being done, or in one session they are being done, and it will be recorded. But you can't have a blanket consent. Blanket consent is not acceptable at all. There are in fact multiple judgments, both from the National Commission in the Consumer Redressal Forum and also in various courts, where the blanket consent has been rejected. So blanket consent cannot be taken. Okay. Any more questions? So again, another question from Ms. Neha is, for COVID-19 patient, is taking consent different from any other procedure? No, madam. No. The consent remains same. The COVID-19 patient will have additional issues of the patient being the source of infection. So this you may explain that the patient will be the source, but then so will be a situation in HIV positive or a hepatitis B positive patient or a hepatitis C positive patient, or for that matter, any patient who has sepsis and is being taken up for surgery. So they will all be the source of infection. So from that perspective, it is not different, nothing different. You cannot deny care to a patient based on the infection that he may be having. And yes, the protection that the healthcare staff will take is something that is not part of today's session, but protection has to be taken. Dr. Rupashri again, consent in case of minors. So, madam, the in case of minors, that is all below the age of 18 years. That is the age of majority for our country. So the consent will be obtained from their parents. They become the people who will give the consent. If the parents are not available, then the guardian. So who is the guardian? Typically, a guardian will be a person who has either adopted a child or who has been appointed as a guardian. This is a practice in lots of, especially situations where a child may be studying in a particular school or a college, and he is staying in a hostel in a different city. So there, in most institutions, they have a system of a local guardian. So this person becomes the guardian in order to give this consent. If such a person is not nominated, then somebody from the school authorities becomes or the college authorities becomes the guardian. Now, this is necessary because the parents are not available there, and the procedure has to be carried out today itself. That means there is no time to delay. There is no scope to delay. If the scope to delay is possible, then the parents' consent is necessary. So the surrogates will only be taken when the delay is not feasible. In all other cases, the parents should consent. I hope that clarifies. Any more questions? Yes, Dr. Ashish, you have something to comment.
Yes, sir. Firstly, am I audible, sir?
Yes, you are.
Sir, I just want to know one thing. In one matter long ago, in Dr. Prabha Manchanda versus Samira Kohli matter, in
Yes,
which there had to be, Samira Kohli versus Dr. Prabha Manchanda matter.
Yes.
In that, there had to be a change in intraoperative procedure where a total hysterectomy had to be performed. Now,
Correct.
in such cases, taking consent is obviously extremely difficult and at times impracticable. So, in such case, especially with the present set of, barrage of litigation that is going on, is it advisable to have a kind of video recording of the situation or something, sir?
See, we can add elements to our process, and sometimes these adding elements like video recording and all may complicate our own processes. Consent is something which is a very frequent requirement in the hospitals, and therefore it is in our interest to keep it as simple, at the same time legally correct. So video recording, except in cases of human organ transplant, it is not required by law. So in my opinion, we should not get into any of this video recording, because what will happen is that there is no end to how much detail can you go to. So just, the idea is that we meet the requirements of the law rather than trying to see. Now, your question that in this particular case, so in this presentation that I showed today, the rationale was taken from this Samira Kohli versus Dr. Prabha Manchanda case itself. And that is a landmark decision because that clarified the scope of consent. Now, the Supreme Court is very clear that unless there is an intraoperative emergency, which the treatment of which cannot be delayed, you can do this. In all other instances, you cannot change or add a procedure intraoperatively. Even in this case of Samira Kohli versus Prabha Manchanda, the hysterectomy was not an emergency. There was no necessity to conduct the hysterectomy procedure. The the consent was only for the diagnostic laparotomy, and in that the hysterectomy was added, which amounted to a modification and combining a therapeutic procedure along with the diagnostic procedure. That is what was objected, and therefore the Supreme Court judgment on this. So the scope of consent cannot be enlarged intraoperatively, except in those situations where there is delay, the waiting is not possible. I mean, if there is a bleeding happening, naturally the consent will, there is no need to take a fresh consent. However, in all cases, the fresh consent is required. I hope that clarifies.
Yeah, absolutely, sir. I'll just take one more second more. Do you feel
Yes.
in that case hospitals in their documentation or policy procedures must highlight this clearly so that patients are aware?
Uh, the hospitals are expected to do that. In fact, even in the NABH assessments, a lot of assessors do get into this discussion and interview the patients as well, whether they have been explained all the aspects of a particular procedure. But yes, it is something that is not followed across the board. So, and the recommendation, of course, is that it must be followed. So that's how it works. But the
Thank you so
hospitals
much.
must explain. I mean, if there is a possibility that the scope of the surgery or the treatment may need to be enhanced intraoperatively, then that should be explained and recorded. I mean, the courts look at it totally differently. I mean, we may have a perspective that as a doctor, we are working in the best interest of the patient. In this judgment of Supreme Court, they have very clearly said that the autonomy of the patient is supreme. I mean, our intention, bona fide or not, is something that is at a not the consideration. I hope that
Thank you.
clarifies.
Yeah, absolutely. Thank you so much, sir. And if we may have the presentation also in the mail or somewhere, we shall be grateful, sir.
Yes, so I've requested emails and a lot of emails have come, so it will be sent to everyone who's asked for it. That's not an issue at all. We've been, as a matter of practice, we have been sharing each presentation so far in the RFHHA Live. So this practice is going to continue. Any more questions? Okay, so great connecting with all of you again. Thank you very much, and see you next week, same time, 3 p.m. on Saturday.